Meeting to order. Can you please take a roll call of the members in attendance?
Okay. Rudham,
Present.
Wieskamp,
Present.
Heffley,
Present.
and Norton. Jan, you there?
Yes.
All right.
Any motions to approve the agenda for tonight?
So moved.
I
Right.
second.
So it's been moved and seconded. All in favor of approving the agenda, signify by saying aye. Aye.
Aye.
All opposed? Motion carries. Now it's time for public comment. Is there anyone here that would like to comment on any topic that's not on the agenda? Seeing none, we will close the public comment. Item 4 is the appeal of administrative decision.
Actually, that's a typo, so it should be a variance request.
Okay, very,
Yep.
sorry.
I do have a newer agenda in front of you
My
that we
apologies.
updated.
Yeah, I just
That's good.
figured out.
No problem.
Thank you. So, item 4 is a variance request. The request of Joel Baker at 50 North George Street to approve a variance of 315 square feet over the maximum 850 square foot limitation for a detached garage. Total structure is 1,165 square feet. So I'll read through the procedures that we're going to follow, and then we will start with the staff presentation. So the Board of Adjustment is a quasi-judicial body created by the City of North Liberty according to state statutes. The board's purpose is to decide on applications for variances from the zoning ordinance and appeals of decisions of the city zoning code official. The Board of Adjustment is an independent volunteer board made up of North Liberty residents and is not a part of the city administration. We are assisted in our work by the city's attorney's office and by planning staff. Prior to this meeting, board members received the materials submitted by the applicants, the staff report reviewing the application, and any correspondence submitted by members of the public. Board members have not discussed the application or its merits with each other, city staff, the applicant, or any other members of the public in advance of this meeting. All consideration and discussion by the board takes place in an open meeting here tonight. The board bases its decisions on facts and evidence allowed by city code presented in open meeting. Concise and truthful testimony helps us a great deal in our decision-making. Public comment is permitted on an item when the agenda so provides. We ask that if you wish to speak, that you come to the podium, state your name and address, and speak clearly into the microphone so your testimony can be heard by all present and by our minutes taker, as all the testimony becomes part of the public record. We ask that the proceedings be orderly and that when you are recognized to speak, you address your remarks to the board. If this hearing becomes lengthy, we will require testimony to be focused on new facts or on information not already presented. The order of proceedings is determined by the board's bylaws and is set forth on the agenda.
I think we're good for, and I can summarize staff report.
So, first is the staff presentation. Can you please summarize it?
Thank you, Mr. Chair. As you mentioned, this is a variance request at 50 North George to approve a variance 315 square feet over the max 850 square feet for a detached garage, and that total structure would be 1,165 square feet. I have an image that's part of the application. On the left, you see the detached garage, existing 832 square foot detached garage. And then circled in red is the carport addition, and then that adds up to that total square footage. I don't think I had this last time when we did the appeal because the aerials weren't out, but this on the left is a 2024 Johnson County GIS map that shows the aerial, but it shows the location of the existing residence. North would be up. And then so you see the residence to the west, the existing detached garage on the north side, and then the addition to the south. And then the picture on the right was a May 15th, 2024 image capture taken from the east off the property in the alley, the public alley, and you could see the addition as constructed. Just to summarize, series of events that occurred in spring 2024, this addition became aware to the city, was being constructed without a permit. May 20th and June 17th, violation letters were sent to the property owner. September 24th, 2024, code official, that'd be myself, sent a zoning ordinance interpretation letter. And then December 18th, 2024, the Board of Adjustment upheld the decision upheld my decision that a canopy attached to the detached garage is subject to the maximum 850 square foot limitation. In July 2025, variance application was submitted, and then here we are today, August 20th, Board of Adjustment considers a variance. The existing zoning is RS8, which is our single unit residence district. I guess the important part is just remember it's an RS. And this is the code provision, 169.05.2A2. And it talks about the 850 square foot maximum for RS zoned properties, which this is. I've put an asterisk below that. And I just wanted to state for the record that consideration should only be given that the canopy is attached to the garage and the overall structure is subject to the maximum 850 square foot limitation for a detached garage, which is consistent with the board's ruling on December 18th. So we really shouldn't talk about is it attached or not. You as a board have already ruled on that. Interestingly, as of July, I believe it was, the state of Iowa, the state legislature amended the Iowa State Code 414 as they apply to variances. They've lessened the standard for approval. We have not had time to catch up with our ordinance to reflect that. However, the standards by which the application provided consistency with those new standards. So we are following what the state legislature had provided. The applicant needs to achieve consistency with each of those. And so what we're talking about tonight is consistent with what the Iowa legislature adopted. And we'll go through that a little bit more. This variance request pertains to the bulk requirements and is therefore subject to, and I put in quotations, practical difficulties standard, which is what the new law is all about, 414 is all about. Just a quick summary of some public input. We don't have any objections to the request. The application includes a letter of support from the applicant's owner at 40 North George Street, and that is incorporated into the packet of information.
I think the applicant's neighbor.
That's correct.
I thought you may have said owner.
Oh, sorry. Thank you. Okay, so a little bit about the approval standards. In order for a variance to be approved, the applicant must demonstrate how the request achieves consistency with each of the following criteria found in 414.124. And we've numbered them. They were a bit, and if you go back to here, it was just in paragraph form. We put them as numbers 1 through 5, and 5 was A and B. They must demonstrate consistency with every single one of these criteria in order to warrant that they've met the test for approval. And so they need to achieve, it's not, they need to meet one of them or 2 or 3, they need to meet all of them. So the application was set up like that we had these numbers similar to this fashion, and we provided an analysis based on each of those. And we'll just kind of go through each of those. The first one is that there exists one or more special conditions unique to the property. In the application, the applicant is claiming that topography of the property has changed with respect to removal of trees that previously provided shade. I note in our response that this position is interesting because it's a lack of a feature that's being claimed as a practical difficulty. I have a wide open space in the back of my yard in town, and I wouldn't argue that I should be able to build something that exceeds the maximum size in a code because I don't have any trees or any shade there. I won't call it That's a precedent that I think could be dangerous. I know these variances stand on their own merits, but I would express that would be concerning to me to agree with that. Also, it's staff's position that topography relates to unique physical characteristics of the property, such as steep slopes and unusual shapes, that make strict adherence to the zoning regulations not practical, or as they called, practically difficult, if it were. The applicant does mention the narrowness of the lot. However, all of the lots within Zeller's first edition, and it's hard to see up here, but because it's an old plat, but I provided a copy of Zeller's first edition, which is the subdivision plat. All of the lots here are similarly shaped and of similar size. And so it's difficult to claim that one of those lots within all of these similarly sized lots, that this lot is unique. Staff just disagrees with that. Also, if you are familiar with North Liberty, we're relatively flat except for a few areas in town, so you don't have steep slopes or anything like that. The subject property as well as the whole area is relatively flat, so you don't have the steep slopes condition, if you will. So at least with respect to number one, it's staff's opinion that one or more special conditions unique to the subject property do not exist. Number two is because of one or more special conditions, strict adherence to with the certain area, dimensional, or other numerical limitations set forth in the zoning code will cause practical difficulties to the property owner in realizing beneficial use to the property. It's staff's position that the applicant is not being denied the ability to construct a canopy. A detached canopy, similar to the previous one that they had, I think they've mentioned that before, up to 200 square feet would be permitted. And actually, if you look at the 2019 aerial, it shows a detached canopy. I believe they mentioned that it was blew away in the derecho. But that being a detached canopy, assuming it was 200 square feet or less, meets city code and would be allowed there. The problem is attaching it to the other structures where it became a problem. Also, a canopy attached to the existing residence and not attached to the detached garage could be permitted as long as you met required setbacks. That wouldn't be a problem either. We've also talked to the applicant about a breezeway. You could attach a breezeway to the home, thereby attaching the detached garage and the canopy structure, incorporating it into the structure of the house. I will admit that alternative has some challenges because you need to make the garage have frost-free footings, and it doesn't have frost-free footings because it can't move independently from the house. So that is an option, albeit an expensive one probably. Again, they're not being denied the right to have a canopy. So it's staff's opinion that one or more conditions to the unique property do not exist. So we don't believe that they meet that criteria as either. Number three, the beneficial use is otherwise permitted to the property. This is just another way of saying you can't ask for a use variance. Like you can't ask for a variance to do an automotive garage in a residential district because the zoning doesn't permit it. We agree that the application meets the standard. It's an accessory use in a residential district, so we have no problem opining that they meet condition number three. Number four, the practical difficulties are not created by the property owner. Again, it's staff's position that there are no practical difficulties. However, if there's any testimony pertaining to the structure being erected, that the expense of the structure to modify it or to remove it, that certainly, in our staff opinion, cannot be claimed as some kind of practical difficulty. Certainly, erecting a structure without a permit doesn't give you that ability to do so. So Again, it's staff's opinion that their practical difficulties do not exist on this property. So it doesn't, the application does not achieve consistency with number 4. And then number 5 is a two-parter, 5A, granting of the variance of the area dimensional numerical limitation will substantially resolve the practical difficulty. Again, common theme. We don't believe that there's a practical difficulty exists, so we don't believe it achieves consistency with 5A. And then 5B, similar but not significantly alter the essential character of the surrounding area. We do not believe this would alter the essential character of the area, so we believe it achieves, the application would achieve consistency with 5B. So to summarize, staff recommends the board find that the request fails to achieve consistency with Iowa Code Chapter 414.124 regarding 1, 2, 4, and 5A. And that's all I have for my presentation, Mr. Chair. Thank you.
Thank you. It's time for the applicant presentation. If you desire to talk, please approach the microphone, give your name, address, and begin your testimony, please.
Good evening, Dawn Baker.
Can I stop you for 1 second? Janet, can you hear all right? I just want to make sure everyone
Yes.
can hear. Okay.
So far.
Okay, thank you. And then if you can move the microphone down just a little bit, please. I just want to make sure that everyone hears properly. Thank you.
And can I move this so I don't switch anything that you have going on?
The only thing that I just, yeah, I think it should be okay. Yeah, that would be fine. Thank you.
Thank you.
Okay, I'd like to open with just a couple corrections that were stated. On September 24th of 2024, I got a letter from Ryan Resnick stating he agreed that the structure is a canopy defined by Section 167.01 of the North Liberty Code of Ordinances. He opened tonight saying that we had constructed a carport addition, and we have confirmation from the city that that was not agreed, that that was a carport, nor did we build a carport. It is no driveway, not accessible by a vehicle at all. And it was also said that we are 40 North George Street and we are 50 North George Street. The state of Iowa's Chapter 414.12 revised approval standards for variances in July of 2025 this year to give property owners beneficial use of their property, which does not significantly alter the zoning ordinance and is not contrary to public interest, and substantial justice would be done for the property owner. We only have to show one special condition, and we have several special conditions on our property. In Ryan's statement that he in your zoning variance packet, he states that it's staff's position that the topography relates to unique physical characteristics of a property. And he outlines steep slopes and unusual shapes. By definition, physical characteristics also include trees on a property. We have, number one, we have unique special conditions. We had 7 ash trees that were unique in physical characteristics of 50 North George Street. No other property in the Zeller subdivision had as many trees or as much shade in their yards as we used to have. This is a fact. The state of Iowa, Chapter 414.14, we just need to state the special condition we have, and these trees no longer exist because of a disease that has covered different areas of Iowa or hit parts of North Liberty, and these trees became diseased. We had to remove 3 of them. We have 3 others that are scheduled to remove. If you flip through your packet, you will see a picture of an area of our yard, the site plan, where it's covered with trees. Then if you flip to the next page, you'll see a picture where we have no shade anymore. The conditions of our property have changed. Also, the City of North Liberty has a special page on their website talking about this ash disease and the trees in our area. Another second condition that we have, the City of North Liberty acknowledged in their variance statement that the lots in the Zeller subdivision are narrow. These narrow lots, the city approved probably 50 years ago to be built on without future consideration of the residents' needs or representative of today's subdivisions approved under today's standards. This makes our subdivision as a whole a special condition, and then our lot particularly has its own special conditions. We did not create the condition of the size of the lot where our house was built on. Our garage cannot be attached due to setbacks. With the acknowledgement that we do have these special conditions and they exist, if our property were like others, I could make the same beneficial use of the property like many of the new subdivisions and surrounding areas. Just across from Zeller Street in the newer subdivision that was built since zoning codes have been updated, they have screened decks off the back of their homes. In addition to us not being able to build a screen deck off the back of our home, we did not create where the utilities are set up underground. And this is a special condition, also subject to where we can dig to create footings. It would be a practical difficulty for us to dig footings and relocate utilities. The practical solution is to attach the canopy to one side of the garage. And it does not ask, the State Code 414 does not ask us to prove the special condition is unique, only that there is a special condition, which creates a practical difficulty. The new code that was adopted by the state does away with the hardship that the old variance used to ask for. If our narrow lot had the same beneficial use as the other subdivisions in North Liberty, we wouldn't be here asking to attach the canopy to our backyard, detached garage. We would have a garage that was attached to the side of our house, most likely, and we could build off the back of our house. Our house opens up to a driveway. You can reasonably say that the criteria for special condition is met by one of the following physical characteristics. The diseased trees are lost or out of our control, no fault to us as property owners. 2, we have limited backyard due to an alley setback that runs through our backyard. 3, we have utilities running underground that make it difficult for us to dig and pour footings. 4, we have a narrow property acknowledged by the City of North Liberty. We only need to have one to qualify for this approval of a special condition and allow us for a variance that we can build for our beneficial use of our property, and in the spirit of the ordinance 16505 is still observed, with the canopy being used and defined by North Liberty Code of Ordinances as a canopy. On the side of a garage is still a garage with a canopy attached to one side. This provides the intent of the zoning code ordinance, substantial justice to the code, allowing us to have a beneficial use of our property as the state requires for the new standard of practical difficulties was amended to intended to revise variance approvals. Let's see, number 2, because of one or more special conditions, strict adherence with certain areas, dimensional and other numerical limitations set forth in the zoning code will cause practical difficulties. Ryan has outlined that there are different building alternatives. We have shown that special conditions exist, any of the 4 items mentioned above, and in the spirit of the zoning code, this does not significantly alter Chapter 16505. The beneficial use proposed by attaching the canopy in the use of our property, which we are entitled to per the state. If we were to entertain any of these suggestions made, this would create more practical difficulties for our space that we have limited space to use. Due to the utilities underground, digging an extra footing would be difficult, creating unnecessary expenses. The practical solution is to use the outside of the garage rather than finding a way to connect it to the house. Item number 3, the city agrees that the canopy and the beneficial use is otherwise permitted. I skipped over number 4 here. 4. The practical difficulties are not created by the property owner. We are here we submitted a building permit for a canopy structure, and that has been applied for. We are not creating our own difficulty. We are requesting a variance to make a beneficial use of our property. The variance has been applied for to give us a solution to obstacles of a narrow lot by which the city approved these lots and has changed the zoning code after they were built. We have no control over the loss of the physical characteristics due to the trees. And our unique property, which used to give us a yard and a patio coverage where a patio exists. In addition to our lot being narrow, the city chose to keep the grassy alleyways through our backyards, and we maintain these alleyways. We have limited setbacks with the public access through our yards, which is also unique in the old town of the Zeller subdivision. The new subdivisions don't have alleys running through their backyards either. Most of the homes in North Liberty can and do have decks attached to the back of their homes, screened roofed porches attached from the backside of their homes. On our property, the utilities run under the patio where the footing needs to be poured and a narrow lot, and the loss of the physical characteristics of the natural shade cover. We would like to construct a permanent canopy structure attached on one side of our garage that offers alternatives than other than the ones that are suggested by Ryan in earlier statements. Granting a variance to our property does not imply that losing a tree can be presumed the same circumstance on properties without trees or on lots who have lost a tree. Today's building standard lots are much different than Old Town, the Zeller subdivision. This variance request is unique to our practical difficulties on our narrow lot where we have utilities, and this would not be the case for future variance requests by other people who have lost trees because it is not the same size lots. They don't have the same circumstances as the conditions of our lot. I would like to add that I found it very interesting going through your variance approvals and denials that North Liberty doesn't approve very many variances for the citizens who live here and pay taxes and work and reside. But when the city makes an error, they make it right. On November 14th, 2024, the city approved a sunroom addition that didn't meet setbacks, and that didn't go before this board. 1470 Antler Drive. But as soon as they realized that they approved a building permit that shouldn't have been approved, they found a way for a special favor. We have special conditions, and they need to be acknowledged that they are conditions that were out of our control, and we are finding a solution for that. I have a medical need for shade. I have lost the trees that provided us shade. I have and want to construct a canopy that is permanently connected so we don't have future issues with wind and storms. I'm going to leave this right here for now, and come back to whatever questions and comments you have for me.
Thank you. Are there any comments by staff in rebuttal?
Yes. I guess I'll talk about the ones that I think are relevant. Just based on okay. Again, I want to reiterate, a lack of a feature is being claimed as a unique condition, and I just totally disagree with that. I suppose I could, I struggle with, would a tree be considered a unique condition, like a 150-year-old oak or something like that that's at the corner of a property, and I need to construct an addition, and I need to move it to be away from this feature. I think that's something that would be worth consideration, but I don't think you can say a lack of a feature is part of my unique condition here. I have a wide open space in my backyard, and I could claim the same thing. Well, I don't have any trees back here, so I should be able to exceed the limitations in the zoning code and construct something more because I don't have any shade back there. And it's almost like operating in a negative kind of space. Well, we did have these trees, but we removed that feature, and now we're claiming that as a hardship. And to me, that just doesn't make sense. I don't believe in my report I opine that the lot was narrow. I think I summarized what the applicant was saying. And I think I said the applicant is claiming that the lot is narrow. Again, I think they mentioned that it's similar in size to all the other lots in Zeller's First. I don't think they're all the same. They're pretty close. But I'm looking at the Johnson County records, and it shows that the lot is 70 feet wide by 150 feet deep. That's 10,000 square feet of lot area. I lived in Davenport on a 40-foot wide lot. A 70 by 150 wide lot is the same size or larger than almost all of and when I say almost all, I'll clarify, almost all of the single-family zoning developments that we have in the city. And that would be RS6. RS6 zoning class, and again, we're not really seeing anything of RS4, which is even larger size. But RS6 is 7,000 square feet lot area, 70 foot of width. It meets the size of most of the subdivisions that we're seeing in the city. So you can't claim that it's different from all of these other properties. It's the same size or larger. And also, they're entitled to the same thing that all the other RS properties are, an 850 square foot detached garage. I've been in some places where they allow smaller. This is a little bit larger, 850 square feet. So they're allowed up to 850 square feet. They built something that was 832 square feet, almost maxed it out, and then decided they wanted to build larger without a permit. And again, I just don't think that gives you, to build something, I just don't think that there's any hardship there. So I don't think, and again, I think it absolutely fails on the test of uniqueness. And again, I just want to reiterate that they're not being denied the right to construct a canopy. They have several options available to them. I think this is obviously the one it's already built. The path of least resistance, and certainly as in 2019 they had one, a detached structure could be constructed and secured to the ground with footings and tied to some type of foundation and meet wind loads. They just chose not to do that, and it's unfortunate. It's an unfortunate situation, but so those are my responses. Again, I stand by our recommendation. I don't think they meet those conditions as we previously mentioned. Thank you, Mr. Chair.
Thank you. Does the applicant have any comments in rebuttal to that? Okay. Would you like a little bit to collect your thoughts?
Okay, first off, we don't have to prove it's a hardship because that's why the state changed what a variance is now. And we do have the right to construct a canopy. And this is a meeting for a variance, no matter if the canopy is there or not there. We're asking to have it permanently attached to our garage rather than our house. We have applied for a building permit. We would like to build this canopy and finish it and finalize it. The lack of, or the misinterpretation of trees on land. It's your opinion that it's a feature when the definition of a tree on a property is a physical characteristic. And you have to relate that back to a special condition because these trees existed long before I was ever there. And they are no longer there now, so that changes the condition of the property. And if you don't believe our lot is narrow, then you have to consider one of the other special conditions that I've mentioned. And utilities are a special condition on a property because it's not up to us where they were placed at. They also exist, and they present a practical difficulty for us going forward on how we want to finish and permanently construct a canopy on our property. Well, the city should also remember that this is not a carport. It was never presented as that from the first time we spoke. It has been offered for everyone to meet with us, come to the property, look at it, see where it's positioned at from the driveway. I believe that there's one other interesting fact that everyone should remember. On May 1st this year, the governor of Iowa also signed into law that AUDs, accessory dwelling units, are going to be allowed to be attached to the side of a detached garage. What's going to happen then? Is the garage suddenly going to become a bigger garage, like attaching the canopy to the side of it? No, you're going to have to recognize that an AUD is something that somebody's going to live in and it's attached to the side of the garage. And that's statewide. North Liberty can't decide that that isn't a possibility. That exists. And that would seem rather unfair and unreasonable for a canopy not to be attached to the side of a garage when you can now attach an entire accessory dwelling unit to the size of a garage, meeting all the requirements for an accessory dwelling unit, of course. So please keep that in mind, that going forward, you will have people attaching something to the side of a detached garage.
Thank you. So now we're in the board discussion and deliberation.
I think, Mr. Chair, I think
Yes.
there's, to provide an option if there's, I don't think there's anybody in the audience, but.
I'm sorry.
Yep.
Is there anyone in the audience that would like to discuss this matter? Seeing none, we will close that portion and move on to board discussion and deliberation. Question for our legal staff. I knew the other variance procedures well, but as I interpret this one, we don't need to just find one of these as a yes. Do we need to find all of them as a yes, all 5 of these? Or is one of them?
Well, as staff pointed out, the code provision isn't written such as these other criteria, 1, 2, 3, 4. It's a narrative, and you have to break it down.
Are there, okay, go ahead. Sorry.
And which is what staff did.
Okay.
And those are all embedded in those particular requirements, the 5 or 6 with 5A and 5B. They're all in the new code provision. So all of them have to be met. It's not that you meet it if you didn't create it yourself. You're not done with the analysis. It has to be all 5 or 6, however you want to look at it. Those questions, yes.
Okay,
A
so
long answer.
thank you. So the state chapter, that 414.12.4, it's the italics on the top, and then each one of the numbered sections is also part of the state code. Meaning that there exists one or more special conditions unique to the subject property.
Right, you will find that in 414.12 sub 4.
Okay,
You will find the second question in there as well.
okay. Sorry, I misunderstood what you said, and I thought you had said that the city had made those questions up, but that is part of the state code.
Well, they broke it down to analyze it. I mean, that's what I would do too. I
Okay.
mean, if I have to meet this, what do I have to do? I have to meet 1, I have to meet 2, I
Yep.
have to meet 3.
But the state wrote question 1 is there exists one or more special conditions unique to the subject property?
No, this is what the state code is this.
Just the italics on the top.
No,
Oh, sorry.
It's, I'll put it up here.
yeah.
Let's see, it is right.
But in order
That's
to
it right
analyze what the state did, I think you should break it down and look at each of the, I don't want to call them elements, but each of the requirements within. And I think the easiest way to do that is to look at them individually and say, is this met? Is this met? Is this met? As opposed to, is all of this met? Because it's, I mean, that's what I did too. I just broke it down. For example, you've got it, well, it says, to authorize an appeal, such as a variance and so on and so forth, will not be contrary to the public interest where, owing to the special conditions, a literal enforcement will result in practical difficulties. It's kind of your first one, right? And also 5A, the granting the variance will not substantially resolve the practical difficulties. And then question 2 is shortly thereafter, the talks about the beneficial use. And then you have to go all the way down. It talks about practical difficulties faced are unique to the property at issue. They're not self-created. And so when you go through all of those, these questions then are designed to so you folks, as well as the applicants, can go through and show how this meets it. I'm not being very clear, but I do think this is definitely the way to go, is to have these questions answered, because it just breaks it down, all the requirements in here. And it's helpful for the folks trying to make their case to explain to you why they meet it. And it's helpful for staff to say why they don't. And it's helpful for you to say, gosh, is this met or not, as opposed to looking at it all like that. You just go through each of these. And these questions all are based on 414.12 sub 4, the new provision.
Thank you. Other question, is there a legal definition of practical difficulties? I can come up with many different things that are practical difficulties.
Right. No, that's for the board. It's not it's not defined in the code, and it's not a legal term. It's something you see often in the building code, and in other words, granting exceptions in the building code. It'll have certain requirements, including showing a practical difficulty. So it's not an unusual provision in a code, but it's not defined. It's for you folks to use your practical experience and your day-to-day observations on what's a practical difficulty, and to apply that.
Thank you.
Eric, I'll ask a question of Ryan first, and then I'll may make a motion. There's been there's been mention on both sides for both arguments about utilities. There's stuff in our packet about utilities, but I can't find any information about where they're located. And because that is your argument for one of the reasons why it becomes a difficulty to add onto your house, or even where the canopy was placed off your garage, I can't comfortably make a decision to deny or accept without having a plan that locates those utilities so we can see where they're located and if it really is. I mean, you're making the claim.
If you pull up one of the pictures, you
Is
can
there?
see the utility box.
Do we have that? What would that image look like?
I think Ryan has it on.
Do you see it on the, on one of these two pictures? Do you see it?
So, I don't know if you can zoom in, but right where the
Please
bump out-
use the microphone.
I don't know if you can zoom in, but right where the bump out comes out on the side of the property right there, the back of the garage, the right corner of the bump out, and then the left corner of the back of the garage. The utilities run underneath the patio, and the box is sitting right there.
Is that utility servicing your house, or is that a utility easement for the entire neighborhood?
That's utilities serving 50 North George Street to that detached garage from the other side of the house.
Because they use the alleyway for all of the utilities.
The alleyway being the far right of the picture, it appears that there's some power lines?
Yes.
Yes.
That's where all the power for 50 North George comes in.
Okay.
So then, obviously, they just took it this shortest point when they attached the houses. So where the end of our, or where the beginning of our canopy is on the garage, utilities run underneath that pad. That's why originally we attached it to the garage, because when we looked at the garage space and looked at the building ordinances, it was never, it doesn't say anything about a canopy making your garage bigger. All the definition is interior wall to interior wall. The city of North Liberty has decided that we have added square footage to the garage, which according to the state, we don't know yet because we're looking into that legally as well. But because of that factor, we did not pour footings on that end and we attached it. If for a hardship, if we had to do that, we may have to end up trying to move utilities. I don't even know if the utility company will do that.
That's a private service, right?
Yeah, I was going to say that would not be a utility.
Yeah.
That's not a utility.
That's every single lot in North Liberty has a private utility going to it. And I
Well, of course it does, but it
would
comes off
also
the
clarify
alley.
too
But-
that the board
Yeah.
made the decision that the canopy is attached to the garage.
The board made a decision based on your opinion, Ryan.
Correct. But
That was it.
Please stop. So, do you have enough information on the utilities? As I interpret it, I mean, that what I would refer to as utilities would be something that would not be owned by the property owner. So anything that was owned by Alliant or, I don't know.
Like a
this is Lynn
sanitary
County or-
sewer.
Yeah.
Sanitary sewer line running.
Well, yeah, that's where I was going. I didn't know what the utilities were.
Yeah.
So
To me, this, I
it's
mean,
only electrical? That's what I'm understanding?
personal electrical. Property owned by 50 North George Street.
Yeah. So that's the utilities that you're referencing? It's an electrical, underground electrical?
Coming in from the side of the property are electrical utilities, yes.
Okay.
Does that answer your question? Or you said you may have a motion to.
Which, by definition, practical difficulties can be the service to the house. It's,
We haven't said it
yeah,
can't be.
okay.
Did that answer your question on the utilities?
Yes.
Okay. And I'll let you keep thinking. I just wanted to make sure that we talked through that.
I don't. Yeah, I don't. I'm sorry.
I don't have any questions at this point.
Okay. Janet, are you still with us? Do you have any questions?
Yeah, I'm still a little bit uncertain about which or how many of these features are part of the have to be met. I was under the impression that if even one of these criteria are not met, the whole package is considered not met, correct?
Yes,
Yep.
that's correct.
Okay. So even if we granted something about utilities, if the other elements are still problematic, it doesn't matter if the utilities are an issue, right?
That would be correct. The applicant bears the burden of proving all of them, yes.
Okay, thank you.
Yeah, I guess to continue on, I think with what you were saying, one of the ways that I'm looking at it, we talked earlier about the 5 or 6 questions that were posed that the city gave comments on, but the last full sentence in section 4 approval standards. Sorry, I don't have a page number, but section 4 approval standards. The Iowa State Code is in italics at the top, and the last sentence is to receive the requested area, dimensional, or other numerical variance. The property owner must prove that the practical difficulties faced are unique to the property at issue and not self-created, and must also demonstrate that granting the variance will not significantly alter the essential character of the surrounding neighborhood. So the way I look at that, there's 2 ands. So if, for example, we were to say that, there's practical difficulties are faced because of the property, and it will not significantly change the essence of the characters in the neighborhood, but we said that these are self-created, that would not allow us to have ands for all 3 of those conditions, and the state ordinance says that we would not be able to approve it in that case. That's the way I'm reading this. And I agree that breaking it down into those 5 or 6 questions, with 5A and B, breaks that down simpler. I guess, would we like to go through how the city broke it down with through 1 through 5A and B? Do we want to look at that last sentence? Do we want to look at all of this? Does anyone have a preference on how we do it?
My preference would be go just down through the items 1 through 5.
Okay.
Yeah.
So I agree with that. So we need to show that there exists 1 or more special conditions unique to the subject property. So the applicant has stated the trees, the removal of the trees is a special condition unique to the property. They've also made comments about the narrowness of the lot. Any comments on those 2 special conditions?
Mr. Chair, I think you could, somebody could make a motion to, I move that there exists and read it in the affirmative.
Okay.
Each one, right? You could
And
make
then
a
we can have
motion.
discussion.
And then it gets second, and then you could discuss, and then I think I wrote in the staff report, yes vote means you agree that they've met that, and a no vote means they failed to meet that. But it's up to you guys how you want to do it. I'm just here to offer some friendly advice.
I think that makes sense then if we go through them. So we can make a motion and then we can have discussion after that motion before we vote. And let's also, like I said, let's make the motions in the affirmative so that we don't have to say yes to a no. So number one, does anyone want to make a motion about number one? That there exists one or more special conditions unique to the subject property.
I move that the property as it sits is not unique to the neighborhood. There are many other lots that have trees and are also the same exact size. So I move that the property special conditions are not unique to the neighborhood.
Comment on that, since that is.
We should get a second before we, okay, unless you're clarifying the.
Well, I was going to clarify because that's still somewhat in the negative.
No, I think that's.
Is that?
I think that's okay.
You can make it that way.
Okay.
Yep, mine was just a suggestion. If you want to do it that way too, yep.
Okay.
Yep,
So
that would be fine.
If I can repeat that, it was motioned that that we find that there are no special conditions unique to the property. Is that what I heard as the motion?
That is correct.
Okay. Do I have a second?
I'll second.
Okay. It's been moved and seconded that there exists no special conditions unique to the subject property. Is there any discussion on that? Of the special conditions that I heard, narrowness of the lot, looking at the Exhibit B, the subdivision plat, all of these houses are, this is one of the wider lots. As you get to other places, you get to 60-foot wide lots and 61 and, fractional lots. So this is one of the bigger ones in the surrounding neighborhood. So narrowness of the lot certainly is not unique to this property. When it comes to topography, it's flat. There's no creek running through the backyard. I would agree that there are no special conditions. So, any other comments or questions on that? It's been moved and seconded. Could you please take a roll call vote?
Sure. Wieskamp,
Yes.
Heffley,
Yes.
Norton,
Yes.
and Rudham.
Yes. So with what we talked about earlier, that the owner must prove that practical difficulties faced are unique to the property issue. We said there are no special conditions. We have to stop now because the first condition was a no. We can't have the three phrases cannot all be and, cannot all be true if the first one is false.
Right. You could, if you want, continue to go through the other questions, but you're not legally required to do so. Because it has failed. But if you wanted to go through for the purposes of a record, you could, but you're not required to do so.
What would our legal counsel recommend that we do?
I would go through only because, let's say there's a challenge.
Yep.
And the court disagreed with one, but not with the other.
Okay.
Then you'd still, the board would still be successful in the appeal.
Okay.
But it don't have to.
I agree with our legal counsel. Number two, because of one or more such special conditions, strict adherence with certain area, dimensional, or other numerical limitations set forth in the zoning code will cause practical difficulties to the property owner in realizing a beneficial reuse. or in realizing the beneficial use proposed for the property. So, any motion on that? I guess I would motion that there are not any special conditions that would prohibit the owner from realizing the beneficial use proposed for the property, because in number 1, we found that there are no special conditions. One of the sorry, that was my motion.
So from,
Hey,
Go ahead. You broke up there for a second.
yeah, asking, I would prefer, I don't know how to do this in terms of process, but I would prefer that if we vote on them separately, that our motion related to this issue or item number 2 not refer to any decision made in number 1.
I hear you on that. I think the problem is number 1 was about looking at special conditions, and then number 2 is because of one or more such special conditions. So if we didn't find any special conditions, does that make sense what I'm saying? That if we didn't find any, how do we talk about special conditions if we didn't find any?
Yeah, and I can read number 2 again. Because of one or more special conditions, strict adherence with the certain area, dimensional, or other numerical limitations set forth in the zoning code will cause practical difficulties. So if you wanted to make a similar motion, you would say will not cause practical difficulties. And when I say similar, I mean similar in style to the first one.
So,
Can I move what
Yes,
he
please.
just said?
Well, I
I,
think we had a
Move that
motion,
we-
right?
are we
There's no
still on
second.
the initial motion? Okay.
so there's no second. Can we move on to Ms. Norton's?
Right, you can withdraw that
Okay,
motion.
I will withdraw my motion due to lack of a second. Janet, do you want to make a motion then?
I will try to phrase it. I move that because of one or more special conditions do not exist, the zoning code will not cause practical difficulties to the property owner in realizing a beneficial use.
I second that motion. Any comments on that? One comment I have is there was a comment that, it'd be very difficult to connect that other people are able to have a canopy attached to the existing residence. The city did not say that the canopy couldn't be connected to the existing residence. So if the residents wanted to build it that way, they could. Since we're looking in the rear view mirror here and this is already built, they've declined the option of attaching it to the residence because it's already built. So I don't.
Because the building code originally said you didn't need to have.
Thank you.
Well, it's just a bunch of shit. Let's go.
Thank you.
You got one guy calling the shots for the city of North Liberty. It's not right.
Hey, please stop.
Not
Please.
Please stop.
And you all listen to him like he's a fiddler. Good God.
So we have a motion and a second. I made my comments on the practical difficulties wouldn't exist if this hadn't been built already. So, any other comments?
No.
Okay. Could you please do a roll call vote?
Heffley,
As a reminder, the
Yes.
motion was that strict adherence will not cause practical difficulties to the property owner in realizing the beneficial use proposed for that property.
Yes.
Norton,
Yes.
Rudham,
Yes.
and Wieskamp.
Yes.
So, moving on to number 3, the proposed beneficial use is otherwise permitted for the property. So the comment was that it's staff's opinion that the beneficial use is otherwise permitted for the property. I motion that the proposed beneficial use is otherwise permitted for the property.
I'll second.
Any comments on this?
None for me.
Can you call a roll call?
Yep.
Please?
Norton,
Yes.
Rudham,
Yes.
Wieskamp,
Yes.
Heffley.
Yes.
The fourth one, the practical difficulties are not created by the property owner. So the comment from the city was the structure being erected without any city approvals and the expense to remove the unpermitted structure cannot be claimed as a difficulty. Notwithstanding the foregoing, it is staff's opinion that practical difficulties do not exist. Any comments or emotion on that? I would motion that the practical difficulties are created by the property owner. Any second on that motion?
Could you please repeat the motion?
Yes, so I move that the practical difficulties are or were created by the property owner.
I would second that.
Been moved and seconded that the practical difficulties are created by the property owner. Any comments on that?
I guess I have an issue with how that's worded because I deem the practical difficulties as being the existing conditions of the site itself, not what's already constructed. The difficulties would be topography or dimensional limits created by the property boundaries or the structures already there. Just trying to figure out how to maybe word that differently.
I think in the staff report, I had said, that staff doesn't believe practical difficulties exist. And so they didn't achieve consistency with that standard.
I'm just trying to make a motion in the affirmative on that one.
Yep.
And legally, we don't have a specific definition of what, quote, practical difficulties, unquote, are.
Correct.
Do you have thoughts on what you would consider practical difficulties or lack thereof of practical difficulties? Part of my thought of practical difficulties are something that cannot be overcome reasonably. So if there's a creek running through your backyard, having to make a bridge across the creek to support a canopy wouldn't be practical and reasonable. Moving, if you had 345 kV transmission lines running through your property that prevented you from building underneath them, and you had to build in a slightly different, it would not be practical or reasonable to relocate those utility lines. The practical difficulties I heard here were finding a way to connect the structure that's already built to the house, as well as relocating the electrical service from the utility to the house. But that's also that both of those were created by the property owner. Moving an electrical 200 amp service is not unreasonable. It's not a practical difficulty. Maybe trying to figure out a way to connect something existing to a house. Since it was already built,
Those things can be overcome. It's not like you can't move your property boundary, or you can't, regrade a hill or create undue hardship on your neighbor by recontouring grades, things like that. I understand that.
Yeah.
Ryan, I think I heard you mention that the state views cost is not a practical difficulty.
I think
They don't have it defined?
you would have to define as our acting attorney had stated. From my perspective, how dangerous is it to say, I built something without any permits and it doesn't meet code, and saying that's my practical difficulty. I can tell you, as long as I've been in the planning world, 29 years, we've always considered variance requests for something that was built. You kind of had to transport yourself in time and say, we're considering the variance as if it's not there, and they're submitting a variance to construct it. So that's how I've always operated over the past 29 years.
I guess.
And Ryan, is that then the basis for your comment about?
Well, I don't think any I don't think any practical difficulties even exist. I don't think they met that standard. And so, this criteria says that the practical difficulties are not created by the applicant. They're not, because I don't think they exist. And so that's kind of why I'd said, in our recommendation that staff does not believe practical difficulties exist, and therefore they didn't achieve consistency with that standard. But I would agree with the example, like a stream or something, a 42-inch sewer main running through a side of the property, and that compels that I've got to put a structure over on this side. That's a practical difficulty that the applicant didn't create.
Another option, I'm just throwing this out for the board's consideration, is you don't address for the reasons that you've already discussed, and the record would show why you didn't discuss for. So it's really, that's another option.
Yeah. I guess looking at, again, back in the on the page starting with for approval standards. You know, in the first sentence, it says, where owing to special conditions, a literal enforcement of the provisions of the ordinance will result in practical difficulties to the property owner in making a beneficial use of the property allowed by the zoning ordinance. You know, I mean, if you look at, are there practical difficulties? No, I think I would agree that there's not practical difficulties. Are there some frustrations? Yes. Are there some costs that would have to be incurred? Yes. But those aren't particularly unusual when it comes to a residential renovation project. So can I withdraw or amend my motion?
Yes, whatever you, probably I would withdraw it.
Okay.
If the second is withdrawn, then you can just start all over. It's a little clearer that way.
Okay. I withdraw my motion.
I second that.
Okay. So the motion is off the table. So I think the clearer motion would be there are no practical difficulties as part of this variance.
Can you say variance request?
Okay, yes. There are no practical difficulties as part of this variance request.
I'll second that.
Any comments on that?
No.
I would let my earlier comment stand that there's no practical difficulties. There's frustrations. There's items that would have to be managed. But in terms of practical difficulties, all of that is practical and can be done. So, any other comments? Can we have a roll call vote, please?
Rudham,
Yes.
Wieskamp,
Yes.
Heffley,
Yes.
and Norton.
Yes.
Number 5, the granting of a variance of the area, dimensional, or numerical limitation will substantially resolve the practical difficulties.
I would suspect if you agreed that there were no practical difficulties, it'd probably be the same as number 4.
Yep. So I guess I move that there are no practical difficulties and therefore granting the variance request would not substantially resolve something that doesn't exist.
I'd second that.
Any comments?
No.
Okay. May I have a roll call, please?
Wieskamp,
Yes.
Heffley,
Yes.
Norton,
Yes.
and Rudham.
Yes. And then 5B, the granting of the variance of the area, dimensional, or numerical limitation will not significantly alter the essential character of the surrounding neighborhood. I move that granting the variance request would not significantly alter the essential character of the neighborhood. I don't see anything in the pictures that show that this would be that much different from other stuff that's in this subdivision or other areas of the city.
I'll second.
Any discussion?
I'd agree that it is worthwhile pursuit. And I know the neighbor, Mr. Martin, appreciates the effort that went into their property. I think there are just a couple of items that they could be resolved to meet the zoning code. We could get it approved. Like it has some definite positives for the neighborhood. But approving it sets a dangerous precedent for other properties. I mean, I have a modern property with a relatively recent new house, and it's still only 70 by 150 for a lot. So I do think it might open things up for the city and in neighborhoods that is going to be difficult.
Any other comments?
No.
Otherwise, it was moved and seconded that the granting of this variance request does not significantly alter the essential character of the surrounding neighborhood. Could I have a roll call vote, please?
Heffley,
Yes.
Norton,
Yes.
Rudham,
Yes.
and Wieskamp.
Yes.
So now that we've been through these, and in so I guess to summarize all of this, based on the ands that we have to meet, I move that the board accept the previously voted on findings and deny the request of Joel Baker at 50 North George Street to approve a variance of 315 square feet over the maximum 850 square foot limitation for a detached garage.
I'll second that.
It's been moved and seconded. Any comments on this?
None for me.
The other alternative is that we don't have a motion, or if this one fails and we don't have a motion, the variance request is still denied because there's no affirmative motion to approve the variance request. So, but it's been moved and seconded. I didn't hear any more comments. Could we have a roll call vote, please?
Norton,
Yes.
Rudham,
Yes.
Wieskamp,
Yes.
Heffley.
Yes.
So the motion carries that the variance request has been denied. Next is approval of
Yeah, there's a note, Mr. Chair.
Oh,
Yep. That's probably worth reading. Thank you.
In the box.
okay. So the motion is approved denying the variance request. Any person desiring to appeal this decision to a court of record may do so within 30 days after this decision is filed with the city clerk's office. Thank you. So at the end of
you for your time.
the packet was
Thank you.
our
Y'all have cockroaches running all over on the floor.
there was the last Board of Adjustment minutes are at the end. Do I hear is there a motion for them?
So moved to approve the minutes from previous meeting.
Is there a second?
I second.
So it's been moved and seconded. All in favor of accepting the minutes, say aye.
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 All against? Motion carries. Is there any old business before the board?
No.
Is there any new business before the board?
The city attorney Grant Lentz and I have been talking a little bit about amending some of the bylaws. I think we've talked about that in the past, so it's something we will work on, and it's been, I think, a couple of decades probably before it's been updated, so it's worth a refresh and to make sure it's consistent with code. So I'm not sure if we'll bring that back next month, but something we're working on, and we'll bring back to you to vote and approve.
I motion to adjourn.
I second.
All in favor, say aye.
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 All opposed? Motion carries. We are adjourned.